Okay, so hello everybody. For this video, we'll be looking at the court case, New York v. Ferber. Okay, this court case was decided in 1982, and it concerns the distribution of child pornography. So something that might be interesting to learn is that there was a point in time where there were no laws banning child pornography, the production of child pornography, so the possession, the production of, or the distribution and selling of child pornography. This situation, though, started to change in the mid-1900s, and by 1977, which is when United States v. Ferber was the sort of law was made and the arrest was made and things like that about this court case. 20 states by that time had laws saying that you could not distribute child porn. So just about every state said you couldn't produce it. The action was illegal. You know, raping a child was illegal. However, the production of it, the filming of it, was not illegal. That then became illegal because the action of raping a child was directly related to the production. So, you know, there's an issue of if the action is illegal, shouldn't the production of the action also be illegal? However, still at this point, we didn't have many states that had criminalized the distribution, the selling of the production of the said action. Okay, so here's an example. Let's say somebody makes and produces a child pornography video. The person then hands it off to me. I then go and try and sell the video. I'm not doing anything illegal. Alright? That was until the 70s and early 80s, and New York passes this law making the distribution of child pornography illegal. So a little bit of background about the criminal case itself. A bookstore owner that specialized in sexually explicit videos, selling those videos, was caught selling to an undercover cop a video that had boys under the age of 16 masturbating. This was now against the law. The distribution of any sort of sexual material, lewd sexual material that involved minors 16 and under, was was against the law. Alright. The bookstore owner sued, saying that this violated his First Amendment free speech rights. Now before people go, what about this case, how could anybody legitimately argue that selling child pornography is protected free speech? Hear me out, kind of. The Supreme Court has set the bar for the state being able to outlaw certain types of speech, certain types of content, expression, action, to be very extremely, ridiculously high. The state has to come in and really prove that the law is very much needed. The law has to cover a legitimate state interest. So, in this case, the protection of children. The law has to be rationally related to the state interest. Does a law banning the distribution of child pornography relate to, can it help achieve the goal of preventing child abuse and child rape? The third part, the other part here, is that the law must be very narrowly tailored to achieve that specific purpose that the state has an interest in doing. If the law is overly broad, if it, say, achieves the interest the state says it needs to achieve, but it also touches on lots of other areas that the state doesn't have an interest in regulating, that law is unconstitutional. The law also, maybe paradoxically, can't be overbroad, which I just stated. It also can't be under-inclusive. It needs to cover enough sort of actions or all the categories of action and speech within the category they're trying to ban, so that it doesn't look like the court is singling out, the state is not singling out a maybe very narrow, specific type of speech within a broader category of speech. Let's look at the pornography example. If the state said that we're going to outlaw interracial pornography, the court would look at that and say, your ban on interracial pornography is under-inclusive. You're basically going after one specific type, and it doesn't make any sense the way you're going out about it. There isn't anything unique or special about that that also isn't included by any non-interracial pornography. The category is pornography, and you're just attacking one small area of that. So your law would be unconstitutional. That's what under-inclusive might be. Okay, so here's what happened. Ferber was arrested. He challenged his arrest. He challenged the constitutionality of that law on free speech grounds. The New York Appellate Court, that's it, New York Court of Appeals, said that, Ferber, you're right. This law does violate free speech rights. It said that they feared the law was overreaching in that it would also silence protected free speech things, and they went through a list of things like educational materials that might include specifically child sexual acts, but if you're a medical doctor, you're going to open up a textbook one day and see a naked child there, because you have to learn about, children through adults and how to fix things and diagnose things or whatever. The court ruled that this law was overreaching and it could ban things like that. The Supreme Court overturned the New York Court of Appeals decision and said that no, this law is constitutional, that it has a legitimate, it achieves a legitimate state interest and is both narrowly defined in a way that is not under-inclusive nor overreaching. So the law is constitutional. So why did the court rule this law constitutional? It comes down to a couple of basic things. At the very beginning of the selection I gave you in the syllabus, it talks about a number of those reasons. Let's see. One, that they felt it was, the court did, very, very true that the Congress made, or the state legislature made, the correct decision in looking at the research and finding that child rape and child pornography was detrimental to the psychological and emotional health of children. That is something that is a legitimate state interest to protect children. They also said that there's this Miller v. California rule / test that defines what obscenity is. We won't necessarily go into the full definition of obscenity. However, essentially they said the obscenity standard does not apply to this case. Okay? This case, this law does not necessarily meet the obscenity standard for outlawing the distribution of child pornography. There are reasons for that. Just know it doesn't. The court says that the state has that legitimate interest to protect children, and that the advertising and selling of child pornography, that economic motive people have to produce child pornography so they can sell it and make money, is very much connected to people making child pornography. Okay? It's, what do they say? An integral part of such materials. And if you make child pornography, the distribution and selling of child pornography illegal, you're going to prevent the production of child pornography. You're going to prevent the amount of child pornography out there. You're going to make it less, there's going to be less incentive for people to make it because they don't have a market for it anymore. And one other key piece here that I want to pull out is that they say what they're going to do is they're going to reclassify exceptions to the First Amendment to include child pornography. So there are the First Amendment protects lots and lots of speech. So much speech, in fact, that there's a question as to whether or not child pornography is constitutionally protected speech. The court says, up until this point, we don't really have something, or we haven't interpreted out of the Constitution in the First Amendment, we haven't figured out what that meant, in a way that would very effectively ban child pornography. So what the court says is, well, let's make that exception. What we're going to do is we're going to say, now on top of some of the other things that we've said just sort of like flat out don't meet the standard for protected speech, such as obscene material. Another one that might be really easy to relate to, defamation of character. So I cannot run around and put posters everywhere saying, so-and-so is a maker of child pornography and a murderer and all-around bad person. I especially can't do that if I know that I am lying about that. That is not protected free speech, that defamation of character. We have a situation here where child pornography doesn't really fall under anything, so the court says, well, guess what? It's a legitimate state interest. Time to make up that there's a exception to the First Amendment. The state has a legitimate interest in preventing child rape. Therefore, child pornography is distribution of child pornography is banned. So, looking at the court case more in depth, there are a couple of things that the Supreme Court quotes in the law that are both interesting and important for understanding why that this law prohibiting the distribution of child pornography is constitutional. It is not, for example, overreaching. The New York legislature enacted a statute. It says, a person is guilty of the use of a child in a sexual performance if, knowing the character and content thereof, he employs, authorizes, and induces a child less than 16 years of age to engage in sexual performance, or being a parent, legal guardian, or custodian of such a child, he consents to the participation of such a child in a sexual performance. Yeah, okay. So, but here's the key. What is a sexual performance? What does that mean? That could cover any range of action. It could cover dirty dancing. It could be only very filthy things. The statute helpfully defines that for us, saying a sexual performance is defined as any performance or part thereof which includes sexual conduct by a child less than 16 years of age. Then they go further to define what sexual conduct is, because sexual conduct is an ambiguous term that interpretation could vary, and if it's ambiguous, it could make the statute overreaching and thus unconstitutional. But we have a definition for sexual conduct in the statute. Sexual conduct means the actual or simulated sexual intercourse, deviant sexual intercourse, sexual bestiality, masturbation, sadomasochistic abuse, or lewd exhibition of the genitals. Now, let's go even further. What does performance mean? We've talked about sexual performance, but what does performance itself by itself mean? A performance is defined as any play, motion picture, photograph, or dance, or any other visual representation exhibited before an audience. So now we have a definition of performance. There's also another part of this law. It's about the distribution of that child pornography. So now we have what you're not allowed to produce. Now we're making illegal the distribution of what we cannot produce. Here's what that says on distributing a child pornography. A person is guilty of promoting a sexual performance by a child when, knowing the character and content thereof, he produces, directs, and promotes any performance which includes sexual conduct by a child less than 16 years of age. To promote is defined as, promote means to procure, manufacture, issue, sell, give, provide, lend, mail, deliver, transfer, transmute, publish, distribute, circulate, disseminate, present, exhibit, or advertise, or to offer or agree to do the same. So when we talk about what does promoting mean, you could say, well, I didn't promote this piece. I merely gave it to somebody. Or I didn't promote this piece. I didn't have any ads for it. I, showed the video in a movie theater, but I didn't go out to the world and say, hey, everybody, look at me. I'm showing this movie. So I didn't, promote it, tell people they had to buy tickets and promote it or anything like that. However, since we have the specific definition of promote, we know what it means, and we know that the enforcement of the statute won't be overreaching. Alright, so the court has several different issues to look at, questions to ask. The first of which is it in the state's interest to protect children? The court says yes. Does a ban on the production and selling of child pornography relate to the state interest to prevent the exploitation and abuse of children? The court says yes, because, and I want to make this clear, because this actually does have something to do with some current political debates. If you ban something, you make it less available, you make it harder for people to get at it, and therefore there will be less of them, and even people who may want to get it will not, or will have a much harder time getting it. Okay? So there are people out there who would love to watch child pornography. However, because there's a ban on it, even though they really, really want to watch it, they really do, they can't. They can't get access to it. Some people may really want to watch it, but the penalty is so high that they decide not to take the risk. If you ever wonder if banning, say, a product, even something that might be constitutionally protected, if that would lessen the number of those things on the street, if it would reduce any effects that that thing might cause on the street, if it would make it harder for criminals to get access to, in lots of cases impossible for criminals to get access to, thus reducing any negative effects of such things, only a fool would say that banning something would not affect somebody's access to that material, to that thing, whatever it is. Otherwise, if banning it did not work or did not help, why would we ban child pornography? Why would we ban meth or heroin or any other the many things that we ban? If a ban doesn't work in reducing criminal activity, then why would we do it? Bans do work in reducing criminal activity. So if you're curious about bans or restrictions on any items, yes, they do work. If there's less of it, then there's going to be less people having it. Okay, so that's squared away. So the court goes, yes, we have a rational state interest, and this ban is legitimate connected to a rational state interest. The court, though, says, the Supreme Court says, the appeals court, who ruled that this ban on the distribution of child pornography was not unreasonable in light of previous court precedent. However, the court kind of says, because it's not unreasonable in the light of previous court precedent, let's make a new precedent here. Let's change the way we're going to approach this issue. Let's carve out a new specific and widespread exception to this law, or to this free speech issue. So one of the huge things the court is concerned about when it comes to free speech issues and laws that might do anything at all to limit or ban free speech is not just the speech itself that it bans, but if a law is so overreaching that it would have a quote-unquote chilling effect on free speech. Okay, so a law bans something that it legitimately has the right to ban under the current free speech exceptions. However, is the law overreaching enough? Does it cover enough things that any reasonable person might not engage in a certain type of speech for fear that that law has now outlawed that type of speech? For example, I think the court points to, maybe it doesn't specifically point to National Geographic magazines, but maybe it does. Well, I'll say this. There's a TV show out of the England, BBC, called An Idiot Abroad. In that video, there's a guy who goes around and sees the 7 wonders of the world, and in the process of doing that, it's Ricky Gervais, Steve Merchant, and Carl Pilkington. Ricky Gervais is the original, and Steve Merchant are the original guys that made The Office, which the American Office here was an adaptation of the English version, which was the original version of The Office. Anyway, they made this thing, Idiot Abroad. In Idiot Abroad, there is at least one scene that I can remember where Carl Pilkington, on his going around to see the wonders of the world, and Ricky and Steve play tricks on him the whole time, but is hanging out in, I think he was in Brazil, in somewhere in the Amazon rainforest, and there was a tribe of indigenous people, and most of them did not have clothes on. And there were, in fact, ladies and men, or I guess I should just say boys and girls, between the ages of, 6 and 17, that you occasionally saw without any clothes on. The question is that child pornography? It's, in the background, it's a real representation of the human species, right? And a different culture. So you could say it has certain educational merits to it, social redeeming value. Does this law, the New York law banning the distribution of child pornography, would it ban that movie or that TV show that happened to have, in the background, people going about their daily lives just without clothes? If this law would be interpreted as having banned that, or if this law would have had the effect of causing people to not film and distribute An Idiot Abroad, even though An Idiot Abroad would still be legal, if the law had the effect of preventing it from being distributed because people were afraid it would violate free speech rules, or violate the law that it was not protected speech. The court would say that the law had a chilling effect on the free exercise of free speech, So not only must a law be narrowly tailored to achieve the state's goal, but you also got to make sure that a law which affects a free speech issue does not affect the free speech issue, does not ban things in a way that would prevent people from engaging in otherwise protected speech in the, say, universe of that issue. So, National Geographic magazines, talked about the video, National Geographic magazines would still be legal under this law, the Supreme Court says, and it's clear that those things would still be legal under this law. So not only is the legislation the state made not overreaching in that it would ban lots of speech, even speech that would otherwise be protected. But the court also said that the law was not written as to be so overreaching that people would otherwise look at the law and self-censor themselves, and it would then have that chilling effect on free speech. I'm not going to look at this law and say, oh man, I can't hand off my National Geographic magazine to my friend. If I did look at this law and think to myself, oh goodness, I can't hand off my National Geographics to anybody, the court would have said that would have had a chilling effect on free speech, and just because even it has a chilling effect, it would be unconstitutional, even if it meets every other qualification for it not to be unconstitutional. It would be, but the court says it doesn't. So go New York in writing laws. When you look at the court case, there's a section italicized second, and then it begins the distribution of photographs and films depicting sexual activity, etc. Here it talks about how that banning the distribution of child pornography is very much intrinsically related to the state's legitimate interest in protecting children. Beforehand, it also says that the state has a sort of, on the face of it, justification that it needs to protect children. It's just like, yeah, that's what the state does. The state needs to engage and to make laws that protect children, and obviously the making of pornographic films involves raping of a child, and so therefore we really shouldn't even, or don't even need to discuss that part of this case. The distribution is intrinsically related to the production. So really we don't need to discuss that part. The issue is it overbroad or under inclusive? And the court says no, it's not. The third italicized talks about the selling of child pornography leading to an economic motive to produce more of it. And it's in section 3 where you get the stuff about it being overbroad and if it would have a chilling effect on free speech and things like that. And I will say then later on, it talks about this case, I think I mentioned it before, Miller v. California. And one of the key aspects of Miller v. California, for something to be considered obscene, it has to have no redeeming social value, educational value, political speech, artistic merit. They're listed a few other things, but the idea is that sometimes super gross and offensive things can have a legitimate purpose in some sort of social criticism. Okay? We may think or obviously look at something and say, gross, that is terrible, that is wrong, whatever. But if it can somewhat be looked at as having some value, then guess what? It gets to be okay. The other part of the Miller requirement on obscenity is that the work taken in whole has to have the work taken as whole has to have some social redeeming value, purpose, whatever, blah, 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 like I said before. But here's the thing. If, let's say, you make, what was it called? The Force Awakens, the Star Wars movie, The Force Awakens. That has artistic merit, social value, free speech, expression, whatever, blah, blah, blah. If you were to put in the middle of the movie terrible, hardcore child pornography, in the middle of the movie would still not be considered obscene under the Miller test. It would be constitutionally okay, because the work has to be taken as a whole, not any individual piece of it. Okay? So, just because it has that one scene that we would go, whoa, that is totally obscene, if there are other parts of it that are not obscene and we go, yeah, legitimate value, then you don't get to ban it. That's part of the reason why the court says, listen, obscenity in this case doesn't actually work. The state's interest in protecting children is so essential to the state's job, it's so important, that obscenity as a reason to ban child pornography and to uphold bans as constitutional under the First Amendment is not going to work, because it has these holes in it where you could pop in child pornography and it would thus still, create the economic motive there for the production and sale of and possession of child pornography. So the court says we need to just create a new definition or a new exception to First Amendment protected speech and just say, guess what? Child pornography is not protected speech. End of story. And there you go. Looking at this case, there are lots of parts in it that are sort of interesting in how they, tie into Ashcroft v. Free Speech Coalition and Stevens for the United States v. Stevens, or Stevens v. United States. And we can see how this law here, banning the distribution of child pornography, fulfills a legitimate state interest and is not overbroad or overreaching. Whereas if you look at the Ashcroft v. Free Speech Coalition, you can see how, compared to this, they would view the law banning virtual child pornography or fake child pornography as being unconstitutional. As a matter of fact, one of the things that this court case brings up is whether or not this law would affect something that I don't know why I'm pointing over there and looking back, something that the fake child pornography law explicitly looked at or talked about. A film, performance, act, play, whatever, was considered to be illegal if it appeared or it was implied or presented as involving children. Even though there were no children involved in the making and distribution of a film, if there was an appearance or an implication that there's a child involved in it, then that would be illegal. The court said that was unconstitutional. In this case, in fact, it says that the law is constitutional because it only covers pornography that explicitly involves children. The court says that there can be work of social redeeming value that explores the issue of child sexual development, child sexuality, that looks at maybe the horrors of child rape and the effect it has on children. And we wouldn't necessarily want to ban those things. The court says, though, here that in cases like that, whoever's producing it and whoever's distributing that film that does have some social redeeming value, it's not important that an actual child be used, but instead maybe if they want to make it more convincing or something, they could choose somebody of age who looks younger to help maybe get the audience engaged in, the film or the play or whatever it is, and, be the play and be appropriately affected by the message the movie or play or whatever is trying to convey. They say anything that has social redeeming value doesn't therefore necessarily need to actually involve children. This only targets laws involving children. Cool. Thanks. I'll stop there. Hope that wasn't too tough for everybody. Both the subject matter and the explanation of it. And look out for the other cases too. Thanks.